Hi, my name is Jasmine Marquez, and I'm doing my case study presentation on Bradshaw v. Stump. Bradshaw v. Stump, background and contextual information. There's only one case that the Supreme Court has ever considered the constitutionality of inconsistency in prosecutions, and that case is Bradshaw v. Stump. A man named John Stuff committed an armed robbery with his accomplice Wesley. This robbery ended up turning into violence, leaving Mr. Scott wounded and his wife, Mrs. Scott, dead. Stump only admitted to shooting Mr. Stout and insisted that his accomplice had shot and killed Mrs. Stout. Stump took a plea bargain and went to court to plead guilty, which led him to being sentenced to death penalty. Based on theory of the case, after the trial, Wesley ended up going to court where the same prosecutor that sought the death penalty on Stump argued inconsistently that Wesley was the one who had fired the fatal shot. Stump eventually moved to withdraw the plea he had agreed to or vacate his death sentence because the evidence that was found by the state during Wesley's trial cast doubt on Stump's conviction. The motion of withdrawal was denied by Ohio courts, by the Sixth Circuit reversed. Bradshaw v. Stump, a case study on plea bargaining. Defense attorneys typically make their living by the amount of speed of cases that they resolve. This is usually done by accepting plea bargains and as quickly as possible, because if a case takes too long, it can interfere with other present cases. Plea bargains, which is when a guilty plea is given for a reduced charge or sentence, are how over 90% of all cases in the criminal justice system are settled. The goal of a plea bargain in that defense attorney can get the best possible deal for the client. In the case of Stump, he wanted to withdraw his plea bargain because of the Sixth Circuit found Stump did not understand that the intent to cause the death was necessary part of the aggravated murder charge he was given, which made his guilty plea unknowing, involuntary, and unintelligent. Bradshaw v. Stump, research on plea bargaining. Plea bargaining is very common in the criminal justice system, and the main reason is because it can take away some uncertainty of a criminal trial and also decrease the sentence that the client may receive. Going to court can also end up costing a lot of money, and accepting a plea deal could lessen the expenses of an attorney, especially if there's a strong likelihood of conviction. Another benefit that can also come from plea bargaining is for society's right to a speedy trial. If a client accepts a plea bargain, their trial will end faster and lessen congestion in the courtroom, with fees up prosecutors so they may handle more cases. There are also issues that can occur with the option of plea bargaining being so available to defendants. The biggest problem is that some defendants that are innocent may accept a plea deal because they are afraid that if they plead innocent, they might be found guilty if they go to trial. There is also the concern that there is a pressure to end up plea bargaining every case in order to speed up the process and move on to the next case. According to an article, the only restriction the prosecutors have while bargaining with the defendant is they cannot use illegal threats in order to secure a plea from them. This leaves a lot of room for manipulation from the prosecutor, which I believe should be more restricted. If there's a problem caused, prosecutors are even allowed to make threats towards pressing charges on the defendant's family. This seems like an over-excessive technique to extract a plea from a defendant. Bradshaw v. Stump, contributions to understanding the plea bargaining. With plea bargaining being the way that most cases in criminal justice system are settled, there can be issues that arise from that. In the case of Stump, he at first claimed he did not understand that his plea bargain made him liable for an aggravated murder charge, but at the end of the trial he claimed that he had just made a bad deal. An article that I read stated that one of the drawbacks of plea bargain is that some judges and attorneys believe that they can lead to poor police investigation, and attorneys who do not prepare properly for the case. This can lead to a law enforcement relying on making deals rather than actually figuring out the detail of what happened in the case. Some can argue that this can be seen in a case at some, and it can make as questions from the fundamental parts of the justice system and how people are held responsible for their crimes. In this case, both Stump and Wesley had the death penalty sought on them by the same prosecutor that knew one of them had to be innocent. Bradshaw v. Stump, challenges of understanding the plea bargaining. The case involving Stump brought up arguments in courts across the country on if it was unconstitutional to conduct multiple trials that have contradicting theories of a single crime. This was due to the unreliability that was seen throughout the case and in the courts. The appeal to reliability also stems from the Supreme Court's decision that if the testimony a prosecutor states is known to be false, then they are required to correct the illicit testimony that could mislead the jury. The prosecutor in the Stump case did use innocence arguments for both Stump and Wesley court trials, but was not punished for doing so. The innocence theory of the prosecutor did have an effect on the sentencing of Stump, but in the end it came down to the 3-judge panel's conclusion that leads to a sentence determination. And that is the end of my presentation. Here are my references, and thank you.